Welcome, everybody. I'm going to get us started. We are thrilled to be here to debate this question in this somewhat unusual format for ASIL of a debate. The question, as you know, is global justice returning to restorative approaches, and should it? You may notice that I don't look a lot like Wayne Jordash, who is in your program as the moderator, and I just want to acknowledge how sorry we are that he couldn't be here. He is, as many of you know, in Ukraine, fighting for accountability and helping with those efforts. And so we'll dedicate this panel to the victims in Ukraine and to his efforts to help achieve some justice for them. So the past decades have seen a real growth in the use and importance of international criminal law as a means, and some would say the means, of pursuing global justice in the wake of conflict and authoritarian regimes. In the mid-1990s and early 2000s, scholars and advocates, some at least, questioned the growing use of criminal law for these purposes and argued that it was starting to crowd out other tools of promotion of justice and respect for human rights. I think it's fair to say, however, that many of those voices had been silenced by the 2000s as international criminal law became more and more the tool of transitional justice. And the idea of fighting impunity for atrocity crimes came to the fore. Some of the tools that have been less popular than in recent years might be termed restorative tools. And these include, for instance, truth commissions, which were really the dominant modality of addressing post-authoritarian regimes in Latin America for many years. And, of course, notably the South African Truth and Reconciliation Commission, which, even as the ICC was being formed, was still being touted as a model for restorative justice in many fora. There were also traditional justice modalities, such as the Gacaca in Rwanda and the Matu Oput in Uganda, that were talked about much more frequently, I would say, even as few as 5 to 10 years ago than they are now. And, of course, amnesties, which can arguably be termed restorative in some circumstances and were widely used for much of history. So our debate proposition asserts that there may be a turn or return towards these kinds of restorative approaches to global justice and raises the question whether that would be a positive development, if indeed it is happening. International criminal law institutions, especially the ICC, have come under intense scrutiny and criticism in recent years. And that has, in part, spurred an impulse to look toward other approaches. I will say that as we prepared this panel several months ago, before the invasion of Ukraine, that statement seemed more powerful than it does now. I think it's fair to say that the invasion of Ukraine has caused many global actors to turn again towards strongly promoting retributive approaches, including involvement by the ICC. So we're in a little bit of a different world, maybe you could say quite a different world than we were a few months ago in this regard. And that may affect our debate, we'll see. I'll also note that a number of emerging scholars have started to urge reconsideration of the heavy focus on criminal law for punishing crimes after atrocities and authoritarian regimes. And some have even pointed to the growing prison abolition movement in the United States and elsewhere, and the negative consequences of criminal law approaches, including the entrenchment of racism. Notably, in Colombia, we've seen the adoption of a transitional justice model that blends to a significant extent restorative and retributive approaches, and I think we may hear more about that in the debate. So I'm thrilled to have several very accomplished lawyers debating this proposition, and I want to just say a word about the format before I introduce them. For the debate portion of the panel, I've asked our debaters to take on a role that they would not necessarily have chosen and that does not necessarily reflect their personal views. And so I've asked them to do that for the first 10 minutes on each side of the debate, and then we'll have rebuttal, 5 minutes on each side. But then we're going to open it up so that they can nuance their views and tell you a little bit more about what they really think about these issues. We've also deliberately chosen not to define retributive and restorative, and we'll see how that plays out in the debate and what kind of scope we have on those terms. I'm going to be strict with the time so that we're fair to the debaters. And first, I'll just briefly introduce them, and I'm not going to be fair to them in terms of their introductions because I want to get on to the debate, so they're going to be quite brief. In favor of the proposition, we're going to have Christian DeVos and Alex Huneeus. And Christian is Director of Research and Investigations at Physicians for Human Rights. He has worked at numerous human rights organizations and published widely on human rights and international criminal law. And his recent book, recently released in paperback with Cambridge, is relevant to the debate, and it's entitled Complementarity, Catalysts, Compliance: The International Criminal Court in Uganda, Kenya, and the Democratic Republic of Congo, and won the Book of the Year Award from the International Law Association's American branch. Alex is a professor at the University of Wisconsin-Madison Law School and director of their Global Legal Studies Center, and is also serving a 10-year term as foreign expert jurist in the Colombian Jurisdicción para la Paz, JEP, a court that was created as part of the Colombian peace process. Her scholarship is at the intersections of law, political science, and sociology, and she focuses on human rights law, especially in Latin America. Arguing against the proposition, we'll have first Almudena Bernabeu, who is co-founder of the Guernica Group, co-head of Guernica 37 International Justice Chambers, and co-director of G37 Despacho Internacional, and director of the Guernica Center for International Justice. She's an accomplished litigator in the fields of international human rights, criminal law, and transitional justice. And last, but certainly not least, we have Diane Orntlicher, who agreed just yesterday to step in for Jim Goldstone, whom you will see in your programs, who unfortunately wasn't able to join us at the last minute. So we are extremely grateful to Diane for stepping in. She is professor of international law at American University and publishes widely on issues of transitional justice, international criminal law, and other areas of public international law. And she served in various public positions, including as the Deputy for War Crimes Issues in the U.S. Department of State, United Nations Independent Expert on Combating Impunity, on appointment by the UN Secretary General. And I'm realizing that I forgot to introduce myself. Sorry about that. I'm Meg de Guzman. I'm a professor at Temple University's Beasley School of Law and recently appointed judge at the International Residual Mechanism for Criminal Tribunals, and very happy to be here moderating the panel. And with that, we'll turn it over to our debaters for the proposition, starting on my right with Christian.
I'm actually going to start. It's okay. Well, thank you to Meg for organizing this conversation in the guise of a debate and for the opportunity to be on this panel with these luminaries of transitional justice scholarship. The question that was posed actually was twofold. It has a descriptive and normative dimension. The descriptive is global justice returning to restorative approaches, and then the normative, should it? Because of the time limits, we're going to focus on the normative dimension, emphasizing the reasons that restorative justice matters. And by way of a working definition, we'll define restorative justice as a set of principles and practices for responding to criminal acts that shifts the emphasis away from punishment of individual perpetrators to focus instead on restoring the relationships and communities harmed by the criminal act. These measures are characterized by deeply involving those most directly affected by a crime in the justice process, namely victims and survivors, and the community also plays an integral role in the process. We contend that a greater focus on restorative approaches to global justice would be both normatively desirable and overdue, and we'll make the argument in two steps. And we'll do so not in the abstract, but through exploration of concrete and embodied examples. So Christian is going to discuss some of the problematic impacts of the punitive approach as embodied by the ICC. The ICC looms large in many of these conversations, both as a symbol of and vehicle for the punitive approach. And then I'll discuss some of the innovative and impactful aspects of the restorative justice approach as embodied in Colombia's peace mechanism, that the HIEP that Meg just mentioned.
Thanks, Alex. Many thanks to the organizers of this panel. I should say it's a treat to be debating my former professor and mentor, Diane Orenleiker. I want to take a page from the theme of this year's conference, actually, and personalize my own experience as a human rights researcher and advocate to say more about why a return to restorative approaches in global justice is so badly needed. When I graduated law school just over 15 years ago, there was little I wanted more than to work at the International Criminal Court, which was then still in its infancy. It seemed the promise and the hope, I thought, for accountability. As it happened, I never got that job that I thought I wanted, but I got a different opportunity instead: the chance to closely study the ICC's impact in 3 of its early situation countries: Uganda, Kenya, and the Democratic Republic of Congo. So the full fruits of this research are recounted in the book that Meg mentioned, but I want to highlight one theme that the book explores in depth, which is how the ICC and the retributive approach it embodies so deeply monopolized the justice discourse in all 3 of these countries. It was not just about whether and who the ICC might prosecute, but a view that criminal accountability alone was somehow the only worthwhile pursuit. I interviewed advocates from human rights NGOs, judges, donor states, and political officials who time and again spoke of complementarity as requiring, quote, best practices that mimicked the ICC's normative and institutional frameworks, from how many judges should sit in a domestic war crimes chamber to whether a national witness protection agency looked sufficiently enough like the ICC's Victims and Witnesses Unit. Often, the results of this discourse were legally wrong and proved to be politically missed opportunities, in my view, as when a debate in the Ugandan parliament around domesticating the Rome Statute concluded that Uganda could not expand its legislation to include other crimes, like plunder and corruption, as many parliamentarians had been led to believe by an array of ICC-aligned norm entrepreneurs, none of whom were from Uganda. Quote, they say, you may not actually go beyond what the Rome Statute says, and you have to confine yourself to its text. Left unsaid in much of this discourse were the fate of other efforts, what we might call restorative approaches, that withered on the political vine, often because they were seen as competing with dominant retributive approaches. In Uganda, a national reconciliation bill that would have included the establishment of a National Truth Commission was scuttled to make way for a hastily passed copycat ICC Act, while the work of Kenya's Truth, Justice, and Reconciliation Commission was sadly overshadowed by the ICC's failed cases. And it should be said that that TJRC in Kenya had a mandate that far exceeded the violence in 2007 and 2008, but stretched back to post-colonial Kenya. As Tom Maliti put it, the TJRC became a political ghost. A similar fate met an earlier DRC Truth Commission, which few barely knew existed. Even restorative approaches, like Matu Oput in Uganda, as Meg mentioned, were decontextualized and instrumentalized in the service of a retributive framework. Scholars mused, for instance, about whether Matu Oput would pass the Rome Statute's complementarity test, as if the tradition existed only to be harnessed in the service of the ICC's work. These findings surprised and sobered me. They suggested not a lack of imagination about restorative approaches on the part of many local actors, but a competition for political, financial, and human resources in which criminal justice responses appeared to always be the privileged mode of response. Justice was largely understood and prioritized as the exclusive domain of criminal accountability, rather than the plural approaches commonly associated with transitional justice, policy, and practice. So this is not to dismiss the need or importance of retributive approaches. To be sure, there are important and worthy reasons to pursue criminal prosecutions as part of a global justice response, but we should welcome a re-engagement with global justice as a bespoke, multidimensional project that is driven by the needs and priorities of those communities who are most affected. I'm going to turn it back to Alex.
So I'm going to focus in 4 minutes on the Colombia's Special Jurisdiction for the Peace, the HIEP, which was created pursuant to the Peace Accord of 2016 ending the 50-year conflict with the FARC guerrilla. It is a mix of retributive and restorative justice and includes a tribunal and 3 other chambers. Because of its restorative justice aspects, I believe it's one of the most diverse tribunals in the world. Over half of the judges are women. Over 60% come from regions outside the capital of Colombia, Bogota. Almost a quarter are either Afro-descendant or indigenous or both. Over half were not criminal lawyers. Over half were academics when they started, and only half had worked in the judiciary before. Within the HIP, the Chamber for Acknowledgement of the Truth, Responsibility, and the Determination of Facts and Conducts, that's its entire name, has the task of selecting and investigating the most emblematic cases of the conflict. And it selected 7 cases to process, each encompassing hundreds or thousands of individual crimes. And these cases are structured according to 2 different logics. 4 are focused on specific patterns of criminal behavior that were particularly salient in the course of the conflict, such as kidnappings or recruitment of child soldiers. But 3 of the cases operate on a different logic. They are organized by place, focusing on the effects of the armed conflict in 3 remote, particularly hard-hit regions. These geographically organized cases include indigenous peoples, Black communities, and peasant communities as victims, both collectively and as individuals. And there's a lot to say here, but I want to focus on, in this short time, just on one practice or case which exemplifies the virtues of a flexible restorative justice approach. This case, case number 2, focused on areas of the Nariño department in Colombia, and it's overseen by Judge Belkis Izquierdo, an indigenous woman from the Arhuaca people of the Sierra Nevada de Santa Marta. And she's worked closely with the Awa people who are victims in the case. And one of the innovative things that Judge Izquierdo has done is include as victims not only the individuals and the groups, the peoples, she's also included as a victim the territory of the Awa people, which is named the Katsasu. In other words, the Katsasu, a non-human entity, has the same rights as humans harmed by the conflict, rights to truth, to justice, and participation in the process. The case is still unfolding, and we have yet to see what the restorative measures will look like. But of course, this idea of bringing in a territory as a victim points to many new possibilities. Just 3 weeks ago, the Awa issued a report to the HIEP in which they offer it guidance in how the HIEP should approach the Katsatsu as a victim of the conflict. And they write, the accreditation of the Katsatsu as victim is itself an act of restorative justice in that it allows the translation of the Awa cosmology into the language of international law and human rights law. It's important from their perspective for the HIEP to understand that the Katsatsu is not only their land, their physical land, but a site wherein or through which the different worlds in the Awa cosmology come together, such that harms to the Katsatsu are a direct harm to the Awa people and vice versa in a way that defies the nature-culture distinction of Western culture. The significance of the Katsatsu as victim has been great and throws into relief the virtues of a restorative process that allows victims and communities a voice in shaping justice measures. And all this speaks to the greater ability of restorative justice to allow meaningful and co-equal role for indigenous peoples in fashioning measures that resonate with their perspectives, as well as meaningful measures to respond to ecological harm and structural harms.
Wow, you are exactly on time. I'm really impressed. All right, so now we will hear from our anti-proposition side, starting with Diane.
Thanks. It's a pleasure to be here. And for my part, also a special pleasure to once again be on a panel with Christian DeVos, my former student, of whom I could not be more proud. So the first point I want to make is really in the form of a question. When our esteemed moderator asks if there's been a turn or a return toward restorative approaches, I want to ask by whom? By whom is this turn being steered? Because of course, it's easy to find scholarship that faults what some call the dominant approach to global or transitional justice. But I want to know who are the supposed people steering this turn away from criminal accountability as one measure. And I would never purport to speak for victims of atrocities, particularly in a situation where I haven't been deeply involved with them. But based on my extensive experience in engaging with many victims in many horrible situations around the world, I'd be astonished if Ukrainian targets of Russian forces' merciless attacks on them demanded that the international community, which, as our chairwoman noted, is now investigating atrocities with a view toward future prosecutions. I would be astonished if victims demanded that they instead turn away from that and focus on restorative measures at this point in their experience. What I've heard from countless victims in many, many countries is a powerful demand for criminal accountability. In fact, everybody who's worked in this field knows that landmark trials that we tend to cite as successes of global justice came about typically, and in no small part, in response to the organized demand of victims. Now, that's not to say that victims have always been happy with the performance of criminal tribunals. Far from it. As Christian DeVos elucidated, and as I developed at great length in my book on the experience with the Yugoslavia war crimes tribunals, victims often have myriad complaints. And when I would interview survivors in Bosnia, for example, about their perceptions of the Yugoslavia war crimes tribunals, I would be initially given a litany that would go on often for well over an hour, well over sometimes 2 hours, of their disappointments. They would catalog at great length how the ICTY, the Yugoslavia War Crimes Tribunal, failed to meet their expectations. And I would always follow that up by asking, in light of everything you've just told me, looking back, was it a mistake to create this tribunal? Should we have focused on other measures instead? And they would invariably, or almost invariably, with one or two exceptions of hundreds of people I interviewed, say, absolutely not a mistake. How could you even ask that? If we didn't have the Yugoslavia tribunal, we wouldn't have gotten justice. So their chief complaint was not that there was an overwhelming focus on justice, criminal justice, but that they didn't get enough justice or that it took too long. Now, I also want to make clear, and here I'm in agreement with the people on the other side of this debate, none of these people would say that criminal prosecutions were all they needed. They saw a need for many other measures of justice, many other types of justice, and as well as non-justice measures that would help their country get back on its feet economically and in other respects. But, and my really important point here, is that victims in many, many, many situations desperately want justice. Before I make my next point, I want to say that, and picking up on the question of restorative versus retributive justice, I found a frequent tendency in many debates to denigrate victims' desire for justice in the form of criminal prosecutions, to treat them in a dismissive fashion as though they were prompted by an unworthy desire for revenge or retribution or an impoverished understanding of their own needs. And in my experience, victims typically express their need for criminal prosecutions when they have that need in very nuanced and wise terms. Many have expressed why they think criminal prosecutions are so important as a means of setting the moral universe right again, and express this in symbolic terms. They talk about the importance of their society or the international community, if it's an international court, affirming that what happened to them was terribly wrong. And it may seem obvious to us that it was terribly wrong, but they appreciate and need that kind of affirmation. I want to just make two final points, which is that I question the premises of the proposition that we have overemphasized criminal justice in a way that crowds out other measures of reconstruction and repair. First of all, this strikes me as a classic straw person argument that in many ways reflects views that were articulated as long as 30 years ago. But in the past 2 decades, the field of criminal justice, and here I'm going to refer very broadly and in shorthand as dominant views of transitional and international justice, have embraced a pluralistic approach. This is captured, for example, in the recognition of the United Nations across various different agencies and spokespersons that there is, quote, no one-size-fits-all approach to justice. And finally, I would say that there's been a profound recognition, an emphatic recognition that societies ravaged by atrocious crimes need to take a multitude of measures to assist societies in reconstruction and repair, and that criminal prosecutions form an important, but by no means most important step in that process. Thank you.
Thank you very much. And thank you. It's a pleasure to be here, and hopefully I'm on the right side, so it's going to be easier for me. I would just will emphasize, hopefully without repeating what Diane said, because I think that maybe with a couple of different components, but definitely no, to the premise of the debate, definitely there is not a return, and it shouldn't be a return. I will go even stronger. I think one of the misconceptions or perhaps mistakes is that we always see restorative, retributive as excluding each other or as a dichotomy, when I actually think that there's no such a, or there shouldn't be anyway, such a clear division. And to, again, add a little bit to the point, I think that we should be talking always about this from the victim's perspective and not just what we scholars or practitioners or whomever we are. And I have never in my 20 plus years experience heard a victim that prefers the truth-telling or the experience of putting themselves, in front of a perpetrator as fascinating and complicated and probably beneficial, that may be at some level, versus a retributive, versus a regulated space, a formal space with professional people, ideally, where they can be taken seriously into consideration, heard, and their narratives matter. So I think that is the fallacy, for lack of a better word, where we depart in some of these debates. The victims want retributive justice. And I will say also in that regard that it's also a little bit misleading from my colleagues on the other side to say that the truth commissions were just an alternative versus retributive justice. In many instances, certainly in Latin America, truth commissions and efforts of truth-telling and collective efforts of this kind were done because justice as a retributive manner was not available to the victims. So it was just temporarily available to put themselves, like Argentina, Chile, through these truth commissions experiences. But when the circumstances with the national processes allowed for these efforts to be taken to justice and tribunals and in whatever fashion in different countries, that's where the victims never hesitated to ask and to demand. And we saw that 10 years later into the transitional justice processes. So this is one of example for me. And I think Colombia is really an experiment. We should be cautious in both applauding too loud or criticizing too harsh the effort in Colombia, but I think is where our path should go. And the crucial thing will be, could we have retributive justice, excuse me, with restorative justice components? Excuse me, no COVID, but just a lot of cough for whatever reason. And then, so that is where I think we should be gravitating, we should be looking into and be analytical. Can we then have retributive justice, as I say, with restorative components? And why do I say that? I will acknowledge, and I think as out of honesty and being professionals in this field, the frustration about retributive justice efforts and institutions handling, ICC and other ad hoc tribunals, the frustration is real. I mean, we all know it, and I think that we shouldn't hide behind excuses. I mean, it has been less than what we expected, and it's low, and we can qualify it in whatever fashion. But the bottom line is that there are two components when you talk about investigating and prosecuting international crimes, two crucial things that sometimes we forget. And for me, that should be the core of this debate, that you need context, that the violations are in many instances perpetrated by states or by armed groups or by big structures of power and situations of power and inequity, that they are much bigger than just one crime understood in a national level. So that you need a huge amount of, an important weight on the context, the political nuances, what are the victims, the situations that they were part of, the things that are structural, long-term, in many instances impossible to resolve in a restorative process, but sometimes even impossibly to address sufficiently in a retributive process. And then I saw the time and I forgot the second idea. But so that will be, the context will be crucial and that to me could be the great benefit of incorporating the restorative practices into retributive. And then perhaps, as a global idea, and we can evaluate later, and it's very much what I'm known for and being pretty outspoken publicly, retributive justice will always be the answer, but it will not be complete unless we keep thinking deep and hard on how victims' participation needs to be articulated. We remain scared for reasons that I understand. I was raised in one country with a continental legal system and educated in a different one with common law for many reasons, but until we understand the victim's participation can be professionalized, regulated, and made part of those retributive efforts, we will not get the key. But I think that is what should be the tendency and the new trend. Thank you very much.
Thanks so much. Well, we have some really important points on the table. We've heard that retributive justice has been failing in very many ways. We've also heard that, Almudena say just now, retributive justice will always be the answer, and we heard that victims demand retributive justice. Now we'll turn to rebuttals, 5 minutes per side.
Okay. 3 points in response. One, Diane asks, by whom is this turn being steered, which is an excellent question, and I think speaks to the two dimensions that Alex pointed to this question, both empirical and normative. And I'm not sure the turn is being steered yet. We've spoken about the Colombian experience as one potential such turn, but I think we both struggle to think of other examples of such a return. And so I'm not sure that empirically we are seeing what the question of this panel proposes. I do think the by whom is important, and of course there are victims who say that they seek criminal punishment and want a retributive approach, but there are many victims, and whose voices are being heard, I think is the other question. In Uganda, again, the refrain was also there are so many outsiders here talking about what Uganda needs and wants, and so we have to really grapple with the again, returning to, what is the community affected, and are those the ones being centered? So again, an empirical question, but a critical one. The second point is, I think Almudena suggested that we suggested truth commissions are not an alternative, and I don't believe we suggested that. I think our point is that truth commissions are part and parcel of a larger justice response. The problem that we face is too often that as we try to espouse a pluralistic approach in theory, it's not happening in practice. Even in the Bosnian situation, we've seen multiple war crimes trials from the ICTY to the War Crimes Chamber. We've still never seen a truth commission despite the perseverance of many civil society activists on the ground in country. Why is that? Why did none of the truth commissions succeed in other countries? There was clearly demand. So something's happening in practice that is not matching up with the discourse. Lastly, Al Medina's point that perhaps there could be a retributive component to a restorative component to retributive justice. I think, what if we flip that? What if it's restorative justice with a retributive component? Might actually move the dialogue much further. And to that point, I would just say, I think we have to accept too that the heyday of the 1990s in international courts is no longer where we are. The ICC, at best, can prosecute 4 cases, maybe 5 a year at best. Yes, universal jurisdiction, but again, limited resources, limited political will. There are domestic courts, and those can work in some occasions, but I think the scarcity, frankly, forces us to grapple with restorative approaches.
I'll just add one thing. I really liked how Diane put the demands, or synthesized the demands she hears from victims for retribution as a means of setting the moral universe right again. It seems to me that the flip that Christian just suggested of centering restorative justice might be, if we think of that as the demand, yes, retribution is one way that we can set the moral universe right again, but it will have different meanings to different people and different priorities depending on contexts and cultures. And so if we can view it as one of the tools with which we set the moral universe right again, and one of the tools within a broader repertoire of restorative justice, that seems to me a better framing.
Do we have one more minute?
You do.
Okay.
Okay, well, I'll just add, because part of the reason I think that is because I've just read this report written by the Awa people for the HIP about what they want. And it's all about setting the moral universe right again. It's all about trying to get the katsatsu and the worlds that meet through the katsatsu in the proper order again. And there's barely a mention of retribution. It's really much more about different types of actions, a lot of them having to do with cultural practices and having their cosmovision acknowledged by the HIP.
I also want to add one more point that may be an unpopular audience for this, but to the question of by whom, there may be too many lawyers in this space, frankly. And that's partly why we have this constant argument about the prevalence of retributive justice. And so, a call for anthropologists and sociologists and cultural historians to engage and inform this space much more than unfortunately they have.
Excellent. You are once again right on time. Turning now to rebuttal from the other side.
Super quick rebuttal, and then a couple of ideas to the comments of Christian. To the Truth Commission first, I actually have the same example, but kind of the reverse. What happened in South Africa? South Africa was the most successful Truth Commission, probably as we all know it, and it was accepted that that's what the South African people wanted. It was done with the big intervention and obviously Bishop Desmond Tutu and the church, and an idea that reconciliation will bring the peace to South Africa and bring the country together. And just most recently, the victims who never stop asking for justice have engaged in indictments and relying on the prosecutorial authorities and judges to seek justice in tribunals. So and if you listen to them right now, what they're saying is finally, we never really choose just to give it a closure to the whole thing with the findings of the Truth Commission. One thing that bothers me, and I go with Kristen on that if there's too many lawyers in the room, but one thing that bothers me on the discourse is the criminal punishment and why retributive has to be defined only by the result or the ultimate consequence, which is the punishment. I understand that that's the ethos of a criminal prosecution, but sometimes we forget the relevance and the importance of the process itself. Sometimes, and I think I may very, very, very disrespectfully speak on behalf of some of my clients when the actual punishment at the end was not relevant, but the process by which and I will put another point right here that I forgot before, is how uneven the reality between the victim and the perpetrator is, and how restorative processes, sometimes you run the risk of not only perpetuating that unevenness. I mean, I make up English all the time, and I'm not sure that that's a word, but you know, but also to actually go deeper into the differences that made the perpetrator and the victim vulnerable to that perpetrator, and the perpetrator to retain whatever quota of power or money or control, or just the ability to impose. For me, retributive, and I've seen it, so I'm lucky enough to be in this part of these processes as an attorney, that in these retributive processes, you actually can, even if maybe it's an illusion, but you actually can make it more even, the situation between the perpetrator and the victim. They become more equals, and they are attended and listened, and the space equalizes a little bit, sometimes important differences. And then to the, and I think I'll leave it there because I think I'm taking most of the time for your rebuttal, so I'll leave it there. Yeah? I have more things if you want to later, but.
I'll try to be very quick so that you can use time. I actually think there's been, not surprisingly, a bit of a convergence in our sides on this. I think certainly I agree with my colleagues on the other side of this panel that we need to do a better job of delivering criminal justice to the extent that that's part of the panoply of measures that need to be taken. And so where I may come at this from a slightly different perspective than Christian is that I wouldn't take from the fact that there's been a lot of disappointment in the performance of the ICC, that victims don't want the ICC to be involved. And again, as our chairwoman indicated at the beginning, there's now, when faced with the onslaught of horrific atrocities, people turn to the ICC, and we should listen to that and understand why. But the task is not to turn away from it, but rather to learn lessons from past experiences and try to ensure that these models are more responsive to the needs of victims. And in terms of the goals of these prosecutions, we haven't talked a whole lot about what they do, but I do want to take this moment to say that to buttress the case for an approach that is holistic, that doesn't make trials the be-all and end-all, and again, practitioners in the field have not done that for decades, but rather to learn from social scientists, picking up on Christian's invitation, what the impact is of different measures over time. And there is now an amazing body of social science literature. Hasn't coalesced on single findings, but the gist of many recent studies is that the impact on societies of a combination of measures, like truth commissions and trials, is much better than the impact on future atrocities, to be specific, of just trials alone or truth commissions alone. So we should learn from that experience. Just one little cautionary note on truth commissions. While I've just indicated that it's important to understand the combined impact of truth commissions and prosecutions can be much better than trials alone, I would sound a cautionary note on idealizing the impact of truth commissions. And here I want to just close by underscoring the importance of my colleague's comment about frustrations with the impact of the South Africa Truth Commission. I deeply admire that Truth Commission. I cite it all the time as a model of an important measure that societies can take. But it is important to understand that levels of violence in South Africa are very high, and many social scientists have attributed that in part to the fact that the work of this Truth Commission wasn't accompanied by meaningful prosecutions. And so again, as we de-idealize prosecutions and take a hard look at where they've done well and where they need to improve, we also ought to be wary of idealizing other measures like truth commissions. Thank you.
Excellent. Well, I think that our debaters have done a terrific job of staying in role, first of all, and bringing out some of the most important points on both sides of this debate. I'm now going to free them from their roles and allow them to speak as freely as they wish about their personal opinions on the topic. And I'll just sort of say a couple of words by way of summarizing where I think we've come to, and you can, of course, disagree. First, I think with regard to the first part of the proposition of whether there is a return happening, I think that the pro-restorative conceded that point. I think that, in other words, that there's not really much of a return happening. If Colombia represents something of a turn, that might be the only evidence, or at least there's not much evidence beyond that, of a return. On the second part of the proposition, however, the normative part, I think we do have, at least while folks were in their roles, some difference of opinion. And one of the ways that we might frame it, I think, is in terms of which should be dominant, right? Because I think that both sides agreed at the end that, you know, a combination of restorative and retributive approaches probably makes sense in many circumstances, but maybe there's a disagreement about sort of the sort of centrality of each of those approaches. And then lastly, I would say that we might have some differences on the empirical question of, that of course is unknowable in some sense, of what victims want. And of course, this is going to be different because people are different, circumstances are different, contexts are different. But those are just a few of my thoughts coming out of the excellent debate that we had. And now maybe I'll turn back to Christian and Alex to see if you'd like to add anything, sort of nuancing your views beyond what you've said in the debate.
I guess I will push back a little on what you just said, or provoke a bit by saying that maybe the HEP experience is not just this one idiosyncratic thing that might be taking place, because by withdrawing from Colombia, the ICC understanding very well the terms of the peace agreement and the way the HEP would work, seemed to be signing off on this model. So we now have the International Criminal Court saying that the way that this is set up, in which it's possible that people who committed war crimes will not actually go to prison but do other forms of punishment, that seems to me a big deal if the ICC has accepted that. And it's something that has a kind of international stature in a certain sense by the fact that the ICC nonetheless it closed its preliminary exam in Colombia. And then I'd also push back just on the point that we've never overdone the push for criminal accountability. I think that there's this, I struggle with this, but the Inter-American Court of Human Rights has said, you know, that every human rights violation has to be investigated and punished at times. It has said that. And there's a big debate within the Latin American human rights community about whether it has gone too far in pushing the state to always respond through the criminal justice system when there's been a human rights violation, and creating a certain inflexibility, which became the center of debate when Colombia was negotiating its peace accord. And there's ways in which the Inter-American Court has retrenched a little bit in its language. When it issues orders for investigate and punishment, now it will hedge and say, you know, if it's required, the punishment. So I think there has been a moment where the Inter-American Court, its regime on questions of accountability, was born and developed in response to the particular crimes that were committed by the military dictatorships in South America, by repressive regimes in Central America, in which forced disappearance was the most emblematic crime. And the regime of, you know, demanding, investigating, and punishment in this kind of very demanding way was developed in response to that. And perhaps so there was a kind of a high water mark for that. And I think that new settings like the Colombian Civil War or internal conflict have caused the inter-American system itself to reconsider the way that it articulated the demand for punishment in the past.
Yeah, I'm unshackled now. I think the only thing I might throw into the conversation is also just like looking ahead to what are our greatest sort of threats? And of course, armed conflict continues, but I'm also thinking to the point Alex raised around ecological harms and structural violence, climate change. You know, are these quintessential mens rea crimes? And how do we think about sort of a forward-looking way to grapple with climate justice? You know, there's conversations around ecocide, and again, in the amendment to the Rome Statute, and I think that's fascinating, but also quite dominant in the discourse. And I'm skeptical about that as investing or over-investing our intellectual and political energies into that, when I think, you know, literally the complicity that we all drinking from a plastic bottle of water here, you know, implies when we think about some of the greatest looming threats. And so I think that's another challenge for criminal law and punishment to grapple with. And yeah, I'm curious for what my other panelists might think about that too.
Thank you.
So as I already indicated, I think there's, in fact, a lot of convergence in some key points among us. And the one that I would emphasize is playing off of what Alex said about the International Criminal Court's reaction to Colombia and the developments within the inter-American system. I think that what she described exemplifies a point I was making earlier, which is that the field of international justice and transitional justice is self-critical and does try to learn from past overemphases. It's very much characterized by course correction, and the fact that the Colombia approach has been embraced widely, I think really it's exhibit A for that. Where I think there are still huge challenges, I mean there are many huge challenges, but the questions that I still struggle with are, first of all, as has already been alluded to, how do we actually meaningfully engage the views of victims and their participation? It's now sort of a mantra of international justice advocates that victims are at the center. It's been part of the expressive function of the ICC to say the victims are at the center. But when we say that the international justice movement is responsive to victims' needs, how do we actually actualize that? And if I could just cite one example to illustrate how I think this question presents itself in real situations. My colleagues Claudia Martins and Susana Zacuto wrote a wonderful article about the Zarco case in Guatemala. What they described was a process in which Guatemalan NGOs worked very closely and integrally with victims of sexual violence during Guatemala's civil war, helped them identify their priorities and support their priorities, which at the beginning did not include criminal justice. Eventually, that emerged as a priority for them. And then at that point, these women felt empowered because of all the other work they had done to seek justice in criminal courts and secured a landmark prosecution. I'm getting time, so I'm going to, in one sentence, say my other priority is, not my priority. An issue I struggle with is how to meaningfully address the issue that Christian highlighted, which is, I would summarize as how international justice attracts so much attention that it tends to suck the oxygen and sometimes resources out of other movements. So it didn't suck the oxygen out of the, as far as I understand, the situation in the Zarco case. It was possible for local activists to address their needs in their space, and that's great, and they didn't need the international community butting in and supporting them. But I think it's true that international justice advocates often speak in a very compelling way, and that's great, that media is attracted to that, but how do we ensure that that doesn't, in practice, actually drown out attention to other voices and other needs? And I think we should grapple with that question in the months ahead as there's huge international attention on the question what should be done in response to Russian atrocities, and ask ourselves, is there a responsibility, for example, for those whose job it is to ensure justice? Do they have a responsibility to say, but that's not the only thing Ukraine needs, et cetera, et cetera? So I'm going to wind up with that question.
You know, at this point, it's reiterating a little bit of the ideas that already came at the table. Just one thing, and not to be antagonistic with Alex, but in the Colombia process, and just to throw it out there, I was able to work very closely with the Comisión de Participación. There's a commission of victims' participation within the special jurisdiction of the peace. And it's pretty precarious how they are articulating that centrality of the victims. I mean, so I just don't want to leave people thinking that it is gutsy, it is definitely brave, and they are trying to dig and appealing to the social sciences finally in the field, why some things work if we do them this way, and why some things don't work. And I think that there's been, so it's a little bit of a lab in testing things that we have done wrongly, you know, for many, many years, certainly the practitioners, but it's still not quite there. So I just wanted to say that. And I also, perhaps, and it's echoing everybody else's, but it's also understanding what the goals are when we embark in these processes of transitional justice, where justice and the mechanism for accountability is so central or so important. What are the real goals? I think that, you know, we all hope to transform societies, and we all hope to to end inequities, and then for people to walk together. And I just think that putting all of that on a retributive process is a lot to ask. I think if you narrow the goal of what a retributive criminal accountability or civil accountability, you know, whatever process you subject the facts, the events, the victims, I think that is also important. Sometimes I just feel there's too much weight on the criminal, and it's important to start particularly working with human beings who expose themselves as plaintiffs, or as to say, well, you know, we always talk also about managing expectations. It's even deeper than managing expectations. It's understanding the limitations of the process. It's run by humans. Most likely it's going to allow us only to present a very skinny portion of the story, of the truth, of the evidence, and we can do this together, but it's important to know, perhaps not to place more than we should in criminal proceedings. That's all I'm going to. And I'm not defending criminal proceedings, but maybe I am.
Well, actually, I think that's an excellent point on which to end. I'm not sure if I'm defending them, but maybe I am, because I think we heard a lot of nuanced views at the end of the day, and I think we can all agree at a minimum that this is an important question to continue to think about for those who are interested in promoting transitional justice efforts around the world and assisting local communities in promoting them, to think about the extent to which the emphasis ought to be retributive and restorative is an important question, and I hope that some of us will continue to work on it. Hopefully you can join me now in thanking our wonderful panelists.